Okay, so real quick before we get into today's stories, a man is scheduled to be executed on April 30th, and the thing that's going to kill him isn't just the crime he committed, it's 40 pages of rap lyrics that he wrote and never published. That's where we're ending up today. Stay with me. Welcome back to Exhibit A List, where pop culture gets cross examined. I'm your host, Jasmine Wegg. I'm a lawyer, and I break down the contracts, power dynamics, and legal realities behind the stories everyone's talking about. Quick reminder, the Instagram is Jasmine Weg ESQ. The podcast IG is Exhibit A List Pod, and I'm on TikTok, Jazz the Lawyer. And if today's episode hits, please follow, rate, review, share the podcast with someone who needs a lawyer bestie in their life. I think everyone does. Okay. Today we have 5 stories, and every single one of them is giving us something different to work with legally. We've got Rebel Wilson caught on tape, and if you've been following the Blake Lively saga, you're going to want to hear every detail of this one because it's all interconnected. Then we're going back to the Real Housewives because we got Leah McSweeney's lawsuit against Bravo surviving a massive motion and a judge basically calling out Andy Cohen's legal team in writing. We've got Travis Scott going to the Supreme Court over a death penalty case that should terrify every artist. We've got Kanye losing a labor lawsuit, sorta. And Selena, her sister, is going after Sheen for something that honestly should never have gotten this far. So let's get into it. So if you've been following the Blake Lively and Justin Baldoni situation, if you listen to this podcast, you definitely have been, then the Rebel Wilson story that dropped this week is going to feel very familiar because the same names keep showing up. The same playbook keeps getting used, and now there's audio. Let me set up the scene for you. Rebel Wilson is currently in the middle of a legal battle over her directional debut of a film called The Deb. The producers of that film, a woman named Amanda Ghost and her co-producer, sued Wilson for defamation after Wilson publicly accused them of sexual harassment and embezzlement. Wilson countersued. There are multiple lawsuits flying in multiple directions. Standard Hollywood chaos, of course. But here's where it gets very Exhibit A list. So, as part of her discovery process, meaning the legal process where both sides have to hand over the communications, audio surfaced this week of what appears to be Rebel Wilson's crisis PR team allegedly discussing plans to build a smear campaign against Amanda Ghost, the producer. Not just any smear campaign, though. We're talking about plans to create anonymous websites that accuse Ghost of being a sex trafficker. And specifically, the language calls her an Indian Ghislaine Maxwell, claiming that she was, quote, procuring young women for the pleasure of the extremely wealthy. They allegedly plan to create a website called Amanda Ghost is a Destroyer of Worlds, which is a sentence that, like, what are we doing here? So now the names involved in the audio are going to sound very familiar. The leaked audio reveals connections to Brian Friedman, Wilson's high-profile defense attorney, best known for representing Justin Baldoni in the It Ends With Us legal war with Blake Lively. The crisis PR operative on the recording is Jed Wallace. Wallace was previously named as a defendant in Blake Lively's complaint against Justin Baldoni, where the allegation was that he planted anti-Lively sentiments on platforms like Reddit, which the Wayfarer team would then feed to reporters to manufacture what looked like organic backlash. And the publicist that's referenced in the text is Melissa Nathan of the agency group, the same firm whose client list has included Drake and Johnny Depp, and who was also allegedly part of the operation against Lively. So basically, the documents in this case say that Melissa Nathan, the PR agent, was being asked for the client to create a smear website and was working with Jed and the lawyer, and both allegedly signing off on it. So what does this mean legally? First, defamation. If you create an anonymous website falsely accusing someone of sex trafficking, that's not protected speech. That would be defamation per se, meaning the damage is assumed. You don't have to prove you were harmed because the accusation itself is so serious. So Ghost's legal team led by her attorney, Camille Vasquez, who you might recognize from the Johnny Depp trial. She was the powerhouse representing Johnny Depp, has called this a profound abuse of power and said that secretly engineering false narratives to win in litigation crosses the line from zealous advocacy to misconduct. Second, and this is what makes this a truly wild legal moment, the overlapping players and identical tactics across the Wilson case and the Lively case suggests a coordinated playbook for reputational destruction across multiple Hollywood battles. So that's not just messy. This starts to look like a pattern of conduct. And pattern of conduct is very powerful in litigation. Third, Wilson has denied everything. She said on 60 Minutes Australia that she had zero to do with the website. She doesn't even know how to create a website. Her lawyers say that Friedman no longer represents her, and a deposition confirmed that the staffer who executed the website never actually spoke with Wilson directly. So the legal question here is, how close does Wilson actually need to be to the instructions for liability to attach? Can she insulate herself by having her team do it while she's telling her team in writing that they, quote, failed to get negative information out about ghosts? That's ultimately going to be for a jury to decide, but I will say this. The discovery process is doing exactly what it's supposed to do. The documents in this case are very, very revealing. The through line here, though, from Blake Lively to Rebel Wilson to every celebrity legal battle that seems to end up with anonymous websites and manufactured online pylon, is that there is apparently a service you can hire in Hollywood where your team will build fake personas, plant stories, and run coordinated disinformation campaigns against your opponents while you maintain plausible deniability. And the It Ends With Us case has essentially ripped the lid off of how this machine operates. I have said that even though Justin Baldoni has had his stands die hard from day one, it is not a slam dunk for Baldoni, and I'm sticking by it. It's almost May, it's almost time for the trial, and I might be right. But with litigation, I tell this to my clients and I tell this to everyone all the time. Judges are wild cards, juries are wild cards, and nothing is completely known until a decision is rendered. But we'll keep talking more about this as it develops and watch the depositions on this one because this will be very informative. And now let's talk about Leah McSweeney because I've been waiting to do this one properly. I have the contract that I pulled from when Leah actually sued Bravo and Andy Cohen. It's the one attached to the court filing, and it tells you a lot of what you need to know about why this case is so significant. Leah McSweeney is a former Real Housewives of New York City cast member, and she filed a federal lawsuit in February 2024 against Andy Cohen, Bravo, NBC Universal, and a number of production entities. And this week, a federal judge denied a motion to move the case to private arbitration. That motion would be by the defendants in the case. And in doing so, basically called out Bravo and Cohen's legal team directly. So most entertainment contracts have mandatory arbitration clauses. You sign away your right to sue in a public courtroom and agree to resolve these disputes privately with a private arbitrator in a proceeding that is sealed from public view. This is enormously advantageous to the entity with the power because private arbitration is confidential, the discovery process is limited, and outcomes never make headlines. Bravo and Andy Cohen tried to push this case to arbitration, and the judge here said no. The judge, by the way, is the same judge, Judge Lyman, who's in the Blake Lively, Justin Baldoni case. Specifically, the judge found that the defendants had participated in litigation. They filed motions to dismiss, they engaged the case in court, and then after that failed, they tried to invoke arbitration. Judge Lyman criticized Bravo and Cohen for them raising it only after trying to get the case dismissed, finding that they had waived their right to arbitration. The judge wrote that the defendants were trying to have their cake and eat it too. In other words, they tried to have their day in court, weren't so successful in getting this dismissed, and now they want to move the case to arbitration. Judge is like, honey, you had your chance. And the judge speculated that the push for arbitration was motivated by the daunting specter of civil discovery being made public in federal court. That last part is key. Civil discovery in federal court is public. Documents get filed, depositions get taken, and evidence becomes part of the record. Bravo probably does not want any of that happening. And now it is. Let's talk about the substance of the case. Leah McSweeney disclosed her history with alcohol use and her disorder and sobriety before she joined Rahoney. She says producers repeatedly pressured her to drink on camera, discouraged her from staying sober, and weaponized her relapse as a storyline. She says that when she tried to maintain her sobriety, she was mocked, called boring, and threatened with lost pay. She alleges that she was denied accommodations, prevented from attending AA meetings during filming, and pressured to continue working through panic attacks and family emergencies. She further alleges that all of this contributed to severe emotional distress, suicidal ideations, and psychiatric hospitalization. She has filed more than 30 causes of action, including disability discrimination, retaliation, sexual harassment, and then a civil RICO claim, arguing that this was a coordinated enterprise designed to violate her employment protections for profit. Now, here's where I want to show you something. I have her actual talent agreement from the court filing, and I want to read you a few clauses because this is exactly what we do on this show. First, and this should sound familiar to anyone who's listened to my Married at First Sight episode, the contract states that the activities associated with the series may include, quote, the consumption of alcohol by artists and others, and asks that the person signing to assume all risks related to those activities. It also warns that participation may expose you to, quote, serious and extreme physical, emotional, and mental distress and injury. There is also a work made for hire clause that gives NBC Universal ownership of essentially everything you say and do during filming. Your appearance, your actions, your statements throughout the universe in perpetuity. And there is a broad confidentiality clause prohibiting you from making any public statement about the show without prior written consent. So the question the court is now going to have to wrestle with is this. Can a contract clause that says you assume the risk of emotional distress actually waive your right to protection under disability discrimination law? Because alcohol use disorder, qualifies as a protected disability under the Americans with Disability Act and under New York state law. A judge already found that. Several of McSweeney's disability-based claims survived the motion to dismiss, so they're still viable. You cannot contract away your civil rights. This is the legal argument at the center of this case, and it is a very serious one. Bravo and Annie Cohen have denied everything. Cohen calls the lawsuit a shakedown. Their legal team has argued that McSweeney was an independent contractor, not an employee, and that reality TV depicting alcohol is protected First Amendment creative expression. And McSweeney is not alone. Former Real Housewives of New Jersey star Caroline Manzo filed her own lawsuit alleging that she was sexually assaulted during the filming of Real Housewives Ultimate Girls Trip, and that producers knew of prior misconduct and they did nothing. Bravo has not aired that season. So what we are watching in real time is a reckoning with the legal architecture behind reality television. The contracts have always said these things. Participants have always signed them. But courts are now being asked whether any of it actually holds up. This case stays in a public courtroom. Discovery is coming, and I will be watching every filing. Now, I said this in the cold open, and I'll say it again. A man is scheduled to be executed on April 30th, and 40 pages of rap lyrics that he wrote and never published are a significant part of why. This story is about First Amendment law, race, and the way the justice system has consistently treated rap music different from every other art form. James Garfield Broadnax was 19 years old in 2008 when he was convicted of killing two men during a robbery in Garland, Texas. That conviction is not itself what the Supreme Court petition is about. What the petition is about is what happened at sentencing. In Texas, a conviction alone is not enough to send someone to death row. Prosecutors must convince the same jury in a separate sentencing proceeding that the defendant poses a continuing threat to society and is likely to commit more violent acts in the future. That is the standard. And in Broadnax's case, the primary evidence that prosecutors used to meet that standard was not a criminal history or expert testimony. It was rap lyrics that he had written and never recorded, never performed, never published anywhere. Pages of creative writing treated by the prosecution as a blueprint for future violence and presented to a jury that the judge himself acknowledged had been shaped by racially targeted jury selection. Prosecutors used peremptory strikes to remove all 7 prospective Black jurors from the panel. During deliberations, the jury twice asked to review 40 pages of Broadnax's handwritten rap lyrics before returning a death sentence. So think about that. The jury asked to reread his lyrics twice before deciding whether he should die. Travis Scott, through his attorney Alex Spiro, filed an amicus brief with the Supreme Court last week. His argument was this: the prosecutors argued Mr. Broadnax was likely to be dangerous in the future simply because he engaged in gangster rap. Such an argument functionally operates as a categorically, straightforwardly unconstitutional content-based penalty on rap music as a form of expression. A separate brief was filed on behalf of Killer Mike, T.I., Young Thug, Fat Joe, NORE, and others, arguing that Broadnax's constitutional rights were violated and that using his lyrics this way exemplifies the racial prejudice that infects a criminal proceeding when the state uses a defendant's rap to capitalize on anti-rap bias, the misinterpretation of rap lyrics. So here's what makes this legally significant beyond the Broadnax case specifically. There is actual research on this. Studies have shown that when you present identical violent lyrics to 2 groups, one group told it's rap, one group told it's country. The group that believes it's rap consistently rates that content as more dangerous, more threatening, more offensive. The same words, different genre, different label, different response. That is racial bias operating inside a courtroom. And the argument being made to the Supreme Court is that allowing prosecutors to use rap lyrics this way effectively makes rap music a proxy for criminality and future dangerousness, none of which are supported by the lyrics, none of which are evidence of anything. The absence of the lyrics from the guilt phase of the trial is, as the brief points out, effectively an acknowledgement by the state that the lyrics had no real evidentiary connection to the murders, but their introduction at sentencing served a different purpose. They were there to make the jury afraid of him, and that worked. The First Amendment protects artistic expression. The Eighth Amendment prohibits cruel and unusual punishment. And the Due Process and Equal Protection Clauses prohibit criminal proceedings infected by racial bias. So all 3 are at play here. SCOTUS has not yet ruled on whether to take the case. The execution is currently scheduled for April 30th, 2026, unless the justices intervene. Let's just be clear about what I'm saying and what I'm not saying. I'm not saying that Broadnax did not commit a crime. A jury found that he did, and that verdict is not what is being challenged here. What is being challenged is whether the art a Black man creates can be introduced at sentencing to make a jury afraid of him and tip the balance toward execution. That is the question, and is one of the most consequential First Amendment questions in hip hop's history, at least one that we're considering today. Right, we're going to take a slightly lighter turn here, lighter in the sense that nobody's life is on the line, at least, because Kanye labor lawsuit verdict dropped this week, and there is actually quite a bit of legal substance here. So a man named Tony Saxon was hired in September 2021 to work as a project manager on West's $57 million Malibu mansion, the one that West purchased and famously stripped of all its interior fixtures and fittings, turned into essentially a concrete shell. Saxon claims that he was also asked to serve as live-in security and caretaker at a rate of $20,000 a week. He says that he only ever received one of those payments. He also alleged that West demanded that he stay on the property, saying, "Stay here now. You can't leave." And that he was sleeping on the ground using his coat as a blanket while working on a $57 million property. Saxon sued for unpaid wages, overtime, and wrongful termination, and a back and neck injury he sustained while on the job. He originally asked for $1.7 million. The jury just awarded him $140,000. West's attorneys argued that Saxon was actually paid $240,000 total, according to bank records, and that his injury claims were fabricated. The jury apparently believed parts of both sides. But here's the part that's interesting. Under California Labor Code, the prevailing party in a wage and hour case, meaning the employee who wins, even partially, is entitled to recover attorney's fees and costs, which means that Kanye would have to pay for Saxon's attorneys. And Saxon's attorneys argue that when you add those in, the recovery could exceed $1 million, which is interesting because then you see that Saxon's attorneys are getting way more money from this whole lawsuit than he's even getting. And finally, let's talk about Selena. Her sister filed a federal lawsuit against Shein in California, alleging that the fast fashion company has been selling unauthorized merchandise featuring Selena's likeness. So we're talking about t-shirts, apparel using Selena's image without the permission from Q Productions, the family company that owns and controls the intellectual property rights for Selena. Shein's response was essentially that third-party sellers did this, they removed the listings, and that they had no idea, but they have policies for when they find out. That defense has some teeth. Platform liability is a genuinely complicated area of law, but it has limits. So if she knew or should have known about the infringing products and benefited from the sales, then they might not have immunity. Also, Selena was murdered in 1995 at 23 years old, and her family has spent 30 years protecting her legacy and her image, and they take it very seriously. A company the size of Shein decided to profit from her without asking, and a cease and desist was sent in August 2025, after which they did keep selling those merchandise. So it does not sound like a mistake. Her sister is asking for all profits from the merchandise sale plus an injunction, which means that they have to stop selling any of the merchandise going forward. I hope she gets both. All right, before we close, petty court is in session. Stakes are low, but always the feelings are high, and my gavel is ready. Today's case hits close to home given everything we've just covered. It's the people versus the person who says, "I don't watch reality TV," like it's a personality trait and a moral achievement. You know exactly who I'm talking about. Someone brings up Real Housewives, maybe at dinner, maybe at a party, maybe in a group chat, and before anyone can even finish a sentence, this person goes, "I don't watch reality TV. I just feel like it's so fake." And then they look around waiting for someone to congratulate them on their evolution as a human being. Okay, first of all, we just spent an entire segment today on the actual contract that Real Housewives cast members signed. And yes, it literally says that show may include reconstructed, stage, and edited scenes. So no, you're not wrong that it's produced. Congratulations, you figured out TV. But here's my question for the court. What exactly do you think you're watching when you tune into your prestige drama, your favorite Netflix series, your beloved documentary? All of it is written, directed, cast, lit, scored, and edited to make you feel specific things at a specific moment. The hero's journey was constructed in a writer's room. The candid interview where someone cries was filmed 17 times until the lighting was right. The documentary filmmaker chose which 90 minutes of 400 hours of footage to show you. All television is fake. All of it is a product. The Real Housewives is just honest enough to put it in writing and make you sign it. Okay, so the charge, performative sophistication. You are guilty, my friend. You are hereby required to watch one full season of any Real Housewives franchise of your choosing. Take notes on the production choices, the editing patterns, and the narrative arcs. And then come back and tell me with a straight face that it requires less critical thinking than whatever you're currently watching and calling prestige television. All right, folks, court is adjourned. That is it for this week's stories on Exhibit A-List. We covered a smear campaign, a smear machine that connects Rebel Wilson directly to Blake Lively's saga, a Bravo lawsuit that just survived its biggest legal challenge yet, a Supreme Court case that could determine whether rap lyrics can be used to execute a man, a labor verdict that proves small wins in employment law can still become expensive for the powerful, and a family fighting to protect a legacy that deserves nothing less. If one of these stories made you think, made you want to know more, or made you want to send it to someone who needs to hear it, please do just that. Follow the podcast on Instagram, Exhibit A List Pod. Follow me on Instagram, Jasmine Weg ESQ. Follow me on TikTok, Jazz the Lawyer. And for this episode, please leave a rating or review. I will accept 5 stars and nothing less. Thank you so much. Please leave it wherever you listen. And I'm on Spotify, Apple Podcasts, YouTube. Let me know where else you're listening to podcasts so I can stream it on there. I'll see you next time on Exhibit A List. Stay curious, friends.